Well, good afternoon, everyone. I want to welcome you here to the last brown bag of 2015. So this is the last in our sesquicentennial series. Boy, I almost didn't get that out this last time. Next year, we will continue to do the brown bags, but we won't be tied to trying to come up with a particular event that happened in a particular month. So we'll be kind of just all over the place. And on that note, we will actually be kind of rotating where we have the brown bag talks. I know most of you are regulars, you're used to coming here, but what we're going to do in 2016 is to have them at Tredegar and at this site on an every other month basis. So the January 2016 brown bag, which will be on About Belle Isle, will take place at Tredegar. And then in February, we'll be back here. So we're going to test this out, see how this works. Hopefully, or definitely, parking will be a little better down at Tredegar, but we're still going to do some of the brown bags here. So, yes, sir. It's still going to be the third Friday. It's still going to be at noon. And we do have some flyers coming. They've been promised. So by the end of the talk, hopefully you'll be able to pick up one of those flyers. We also, at the back, have some evaluation forms. We're really wanting to look at our programming, look at what aspects people like, what you would like to see that's different, and just gather all of that information. So certainly, and Patrick's handing some out, so take one, fill it out. There are some extra pens and pencils there at the back. Well, that's enough of the announcements. So what I'm going to do now is turn it over to our co-CEO, Christy Coleman, and let her have the floor for the next 30 to 40 minutes or so.
All right. Hello, everybody. How are you? Thank you all so much for coming out. We're finally back to some December weather, so should have a fairly reasonable afternoon. So today we're talking about the 13th and 14th and 15th Amendments to the Constitution. And it seemed like a fitting thing to do, given that, as Kelly said, we are ending out our sesquicentennial observations of the American Civil War and emancipation. And to make that happen, one of the really crucial things that takes place following the war is the ratification of these three amendments. And clearly, they were not easily ratified. It was more than a challenge, to say the least. So before we get into all of that, what I'd like to do is just back up a little bit. Let's think about the Constitution, because our conversation today is not only about what happened in 1865 to 1870 when these amendments were passed, but to also talk about a little bit about how they continue to reverberate today, because one of the things that we want all of our visitors, all of our members, everyone to understand is that the Civil War matters. It matters even today. And so we have to be able to figure out how some of these dynamics come to play. Now, I'm going to talk for probably 25, 35 minutes tops, and then we'll do Q&A from there. And I have to admit a certain level of nervousness, because I have my other co back there, and I have our Director of Public Relations and Marketing and a big old camera right there behind me. So that's one of the few times that I actually have to do that, and means I also have to stand here at this podium, which is not usually how I like to do it. I like to move around a little bit, talk to folks. So Leo, Patrick, if you can't hear me, if I start to move and wander and chat, please just raise your hand and I'll return to the microphone like I should. All right, are we ready? All right. So, to start all this off, our Constitution, ratified 1787. And the thing that I think most Americans fail to remember is that this is actually the second go-round in trying to make that thing work. The first Constitution didn't work. It never really resolved some of the issues of how states would interact with each other, how big, how small, how limited the federal government should be, and it just created chaos and just did not work. So they sat back down And they started with their mission statement, for lack of a better term. And that mission statement being the preamble to the Constitution. How many of you know that? The preamble. Raise your hand if you know. Come on, you don't be shy. You know it? All right, well, since you don't, or it might sound familiar, let's start there. Because it begins to, I think, formulate what they endeavored to do. So, we the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States. What I have always found interesting about the preamble is which of those words are capitalized. And when you look at it, justice is capitalized. Tranquility is capitalized. Welfare is capitalized. Blessings of liberty, capitalized. Posterity, capitalized. Now, they did that for a reason, because they wanted to draw attention to these core ideas, and in doing so, lay out the framework of what this new government is going to be all about. So, you know, this particular Constitution was ratified September 17th, our Constitution Day, 1787, and it was finally ratified by all the states June 21st, 1788. So with that, we have our original articles, of course, the articles that are establishing what the government and how the government will be set up. So we have everything about explaining how the legislative branch will work and how the judicial branch will work, how the executive branch, states' citizenships, and all of these kinds of things are covered in the first 7 articles of the Constitution. Now, we also know that the amendments to the Constitution, the first 10, are referred to as our Bill of Rights. And one of the things about the Bill of Rights that I think is really important is that it does make explicit, and this is where we often get into the grand debates about whether or not it was constitutional or whether or not it was right for states to pull away, to secede from the Union, because we find those predominantly in Article 9 and 10, which basically says those powers that are not specifically enumerated in the Constitution to the federal government shall be left to the states or to the people. And so with those, it's the framework of how the individual is to be protected from the state. And that's really how a lot of historians, especially legal scholars, think about the first 10 amendments of the Constitution. It really is about protecting individual rights and liberties of the individual against the formed state, the state being the government, the overall government. Interesting is that what happens next with the passage of the 11th and 12th amendments to the Constitution, we begin to see an interesting little shift. And we really begin to see that shift taking place with the 13th, 14th, and 15th Amendment, which are, in essence, not only expanding what liberty and life and citizenship rights and all of those things mean, what it also does is it shifts the constitutional tone, shifts it to the point where no longer are we trying to necessarily protect the individuals and the states from the government. We're flipping it to protect we're flipping it and adding to that to protect individuals specifically. And so we find that in the first one with the 13th Amendment. The 13th Amendment is a powerful amendment. A lot of people think that this amendment, questioned whether or not this amendment was really necessary, because didn't we have the Emancipation Proclamation? Didn't the Emancipation Proclamation end slavery? And the reality is it most certainly did not. It only applied to the 11 states that were in rebellion. It did not apply across the board to border states. As a matter of fact, it was very specifically designed to keep peace within the border states that were still fighting for the Union at that point. Lincoln knew very well when issuing those executive orders that if he tried to make a blanket statement about this, that he would potentially lose Maryland, he would lose Kentucky, he would lose Missouri. As it was, all 3 of those states in particular had not, had not only people fighting for the Confederacy in units that were formed in those states, but they also, in the case of Missouri specifically, had representation in the Confederate States. So they had congressmen and senators in both governments. This is really an interesting thing. So by the time we get to the 13th Amendment and the ratification of that, Lincoln and the Republicans are very, very clear that once this war is ended, there is nothing that could prevent slavery from continuing unless they made a constitutional movement to do so. Because the reality is, even though the Constitution did not explicitly mention slavery, it does by implication talk about slavery through the 3/5 Amendment Clause, which talked about representation. It also talks about roles in property and individual rights to property. And it does make exclusions relative to Native Americans who were not taxed. So when you put all those things together, they were keenly aware that if they were going to abolish slavery forever in the United States, that it was going to have to be an amendment. And let me tell you, boy, did they do the most amazing political hustle you've ever seen to try to get that passed. And it was, again, there was an urgency to trying to get it done. Historians have argued and talked about and called out all kinds of things that would certainly be unethical in terms of how they went about securing some of those votes, but nonetheless it does pass. And when the 13th Amendment passes, it does change the game considerably. So, and I think one of the other things that I wanted to share with you is that what's interesting is that these 3 amendments are passed within a 5-year period. Probably one of the shortest periods of time to any constitutional change. It had been 61 years when these amendments are brought forth since the last constitutional amendment was done, which was the 12th, obviously. So 61 years, and still that holds the record of the longest period of time where there hasn't been a constitutional change. So what exactly did it say? 13th Amendment, Section 1. Neither slavery nor involuntary servitude, except as a punishment for crime, whereof the party shall have been duly convicted, shall exist within the United States or any place subject to its jurisdiction. Section 2, and this is also extremely important. Congress shall have the power to enforce this article by appropriate legislation. That was the first time, the absolute first time, that any constitutional amendment had included that kind of language, giving Congress the power to actually legislate how these actions would be carried out. It had not happened before, and it would be a subsequent comment in virtually every amendment after it. Well, which raises an interesting question of why. Why, if you're passing a constitutional amendment, do you need to immediately say Congress has the power to legislate how it's implemented? Any ideas? Yes, sir.
Well, I was just thinking as you were talking about that, because I'm familiar with the, Article 1, where Congress, the necessary and proper clause, says in the necessary and proper clause, Congress shall have the power to make laws and rules for any of the so mentioned powers and any other powers they have in the Constitution. So if that becomes part of the Constitution,
why is it necessary?
why did they do that?
That's the question. Why did they do that? Well, there was real concern as to whether or not the southern states were actually going to comply, especially given the fact that you have this portion of the amendment that speaks directly to this idea of unless for criminal offenses, right? So, and what ends up happening in reality is that a lot of very interesting things or minor infractions become, and the way that the jury systems worked, minor infractions could land someone in prison for the rest of their life and thereby become, once again, enslaved through what is supposed to have been a legal process, a due process. So, it's interesting, though, the second part that they did do, one of the first legislative pieces that they do after putting that in is it was the Anti-Peonage Act. And that was in 1867. And the Peonage Act was really not so much designed to assist African Americans or people who were formerly enslaved under the chattel system. It was really designed to protect people who may have been in debt. So it had a greater impact upon poor whites, the Anti-Peonage Act, than did the 13th Amendment out and out. Because what it does is it basically says you can't lock somebody up and put them into this sort of indentured peonage system again where there's no redress, there's no way for them to get out. So that was one of the first pieces of legislation that is passed after this amendment becomes law in 1867. The SCOTUS would uphold it again, the Supreme Court of the United States would uphold this again in a landmark case in 1911 that came before the court. So to prevent states from doing this kind of action. But again, it was very uneven, especially after the era of Reconstruction, and we start having the dreadful period of Jim Crow and the like, that a lot of these rules and laws just go away. Nobody's paying attention. No one wants to get involved with it. Let the states figure it out. And what's interesting, as the states, particularly the southern states, are rebuilding and making their constitutions at the time, they're putting in a lot of restrictions across these. And you'll see more of that play out across the 14th and the 15th Amendments in particular. But today, most of us recognize and accept in the United States that slavery is just a bad thing. We do not want it. It is inconsistent with life, liberty, and the pursuit of happiness. We get that. What we often fail to see are other forms of human trafficking that take place that we often turn a blind eye to. And that is one of the contemporary issues that's coming to play. As a matter of fact, if you just go right down on 95, there's this huge billboard, right, that says, "Human trafficking is happening right here in Virginia. Help stop it." Most of it is related to child labor. Most of it is allowed to the sex trade, is what is happening, is that people are being transported, used, essentially as sex slaves, and it's happening right here in Virginia. And so this is where the 13th Amendment comes into play again, the Peonage Acts come into play again, and trying to protect those individuals and get them out of those systems. But because we tend to think of slavery in completely different terms, we often don't mentally make that connection in terms of what happens. So moving on, let's talk a little bit about the 14th Amendment. That's my favorite, because that one is always in the news. And, oh, by the way, if I were to ask you, what was the last state to ratify the 13th Amendment? Any ideas? Say again? New Jersey, Mississippi? It would be Mississippi. Mississippi finally ratified the 13th Amendment on March 16, 1995. It was not certified until February 7, 2013. Huh? They just overlooked it. Yeah, that's what they said, actually. That's what they said. We thought we already dealt with that. Kentucky wasn't too far behind. Kentucky, interesting, on all three of these amendments, Kentucky is either the second to the last or the very last to ratify these amendments. With the 13th Amendment, Kentucky doesn't ratify it until March of 1976, when we finally see that. So the 14th Amendment. This one is a lot more difficult, and this was one that had a very, very peculiar history. So the 14th Amendment, let's just knock it out of the way, it has 5 sections to it. The first section says, all persons born or naturalized in the United States and subject to jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of the laws. Section 1 is referred to generally as the Equal Protection Law. And this is the one that has really been used, particularly in the last decade, when it comes to gay rights, when it comes to immigration, yes. Immigration is the huge one, because this is where we start hearing, we started hearing the phrase anchor babies, right? And this particular one, when it comes out, I mean, the point of it was to recognize formerly enslaved people as citizens. The first one gives freedom. The second one gives citizenship. If you are born here, you are a citizen, right? That was essentially the intent. And as a citizen, you shall have equal protection under the law. I'm sure we don't need to get into all of that. But that is the one that section 1 is the one part of this amendment that sticks the most out. But there is more to it. Section 2 deals with apportionment. Now, this is where we're talking about how areas, when we're looking at our legislative bodies, how individuals are to be counted and apportioned for that. So it's the idea that you have to count citizens, all citizens, as you begin to lay out districts. And this is sort of the birth of the one person, one vote. So you can't have one district with, say, 100,000 people and another district with just 100 people and then call it equal, because it's not. So this is one of the other pieces of that. Section 3 of this amendment prevents former, this one prevented those who had served in the United States Congress, who joined the rebellion, served in governments of the rebellion, prevented them from serving again in the United States government. Okay, so it's basically a ban. If you were elected here and then you ended up serving in the Confederate States of America's congressional bodies, you could not then return to the United States government. But there was a proviso. And that proviso said, unless, of course, they agree to vote you back in, to release the restriction. So that is Section 3. And part of that was having to swear a new oath and all of these kinds of things to prove that you would be worthy of serving once again and representing. But it blocked a number of people from serving again in the United States Congress. Section 4 is pretty simple. It's about debt that was incurred specifically during the Civil War, that the United States government was subject to paying that debt to its citizens, but it would not pay the debts of the Confederacy. So this meant to pensions and supplies and all of those things, making them all valid. And Section 5, once again, gives the power of Congress to enforce this amendment by legislation. So 14th Amendment, again, a much fuller piece. And again, as I said, it's really important to note that the 14th Amendment is probably, all of them were kind of intense, but this one became really intense for two really good reasons. Now, if you, I like to follow sort of more radical, interesting bloggers and things out there, but this is one where there is a group, and they're a relatively small group, but nonetheless, there's a group that has been fairly rampant in saying that the 14th Amendment is not a legitimate part of the Constitution. And they argue this because after ratifying this amendment, 2 states rescinded their ratification. And the 2 states that rescinded were New Jersey and Oregon. And they do it about a year and a half after it's been ratified. Now, by that point, Seward has already certified that this is passed. We've had the certain number of people. You cannot now rescind your vote. They knew who those areas that had rejected the vote initially. But again, they had the numbers. But because of the rescission, there are a number of folks who say it's simply not, it wasn't valid, and have argued that for the last 50 years, that, there's no way this thing is valid. And that argument is resurfacing itself, especially in light of immigration issues. But trust me when I tell you, it is in fact quite legal, and it is one that the Supreme Court has on numerous occasions reinforced elements of this particular amendment, expanding it out, as have various laws been passed to support it as well. So, but again, that whole process, that was the first time also that we've dealt with recension of a vote when it came to constitutional and ratifications. So that was one of the other ones that I found absolutely lovely. How do you do that? What happens? Legislative bodies change in the states. They had different perspective. And some states did have major shifts. The Republican Party also was really at odds. I mean, you think about when this amendment comes through, when it's finally ratified in 1868, you know, we're setting into the election cycle. Ulysses Grant, you know, basically wins by just the narrowest of margins. And so the party is starting to fracture again. And you also have a number of Democrats that, and we have to be really careful here because we are talking about very different Republican Party and Democratic parties than the namesakes today. They are very different parties than they were at the time. But Democrats have also made a much stronger inroads in some of the border states and even to some northern states. So the philosophies around that are shifting things considerably. Last but certainly not least, and then we'll expand out a bit, is the 15th Amendment. Now, this is the one that deals with voting. And the 15th Amendment, let me get my little cheat sheet here. Yes, this is the first one that I really love. It says, it's important to note that prior to this amendment, there was no expressed right to vote in the U.S. Constitution, the original Constitution, or the Bill of Rights. There was no expressed right of individuals to vote. That comes about really in the 1960s, when that finally becomes viewed as a fundamental right of citizenship. Prior to that time, it really had not been. And once again, this particular amendment passes in 1869, ratified in 1870. The last states are Kentucky and Tennessee to ratify them. Kentucky in 1976, Tennessee in 1997. Section 1. The right of citizens of the United States to vote shall not be denied or abridged by the U.S. or by any state on account of race, color, or previous condition of servitude. Section 2. Congress shall have the power to enforce this article by appropriate legislation. Now, this does specifically extend the right to vote, and as you heard it can't be based on race, it cannot be based on color. It would not include gender until the 19th Amendment, of course, with the passage of allowing women to vote. But this is important, too, because up to that point, Congress had all right and responsibility to make sure that each individual had the right to vote. But they did not. And in fact, what we see in the 1880s and 1890s in particular, again with constitutional development, is that in southern states in particular, as they're developing out their state constitutions, they're putting in poll taxes, they're putting in literacy tests, they're putting in a variety of things, and what was referred to as the grandfathering clause. So anyone that would have had the right extended to them prior to this amendment would not have to be subject to any of that. And it often meant generationally as well. So this is the one law, or one amendment that has had the most legislative actions to try to get the right extended and expanded. We see the first set of civil rights acts come about in the 1880s and 1890s. Most of them don't work. They come back to the table again in the 1920s, do not work, do not get passage, and then we finally get to the 1960s, 1964 and 1965, that these voting rights are extended. and opened up and eliminating all of those restrictions that had been placed depending on where you were in the state. Now, why would something like voting be so difficult for states to incur? Well, you have to remember that, again, as I stated in the beginning, the idea that every citizen had the right to vote really wasn't universally understood or thought to be practiced. It really wasn't. Each state had different rules of how it would extend voting. Sometimes it had property rights. And the challenge of being the federal government is that each state had different requirements, when it related to property, or if it, you had to be 21, or you had to own 20 acres, or you had to have this much wealth, and it varied from state to state, north and south. So rather than tackle those concerns, they again leave it, even within this document, within this amendment, to allow the states to begin to figure those things out and work through them. But this was also an extremely difficult one to pass. But it does eventually pass with the required, and it becomes the hot button issue even again to this day. We saw in the 2014 and 2012 elections a number of changes, especially as districts and lines were being redrawn. We began to see that everything from driver's license requirements to, you've got to have the photo ID, or you have to have this, or you have to have that. For many people, this felt as if a step back away from the Voting Rights Act. There are some places that went even further and said, well, we're going to just shut down polling places in certain areas, and we're going to shut down, what is it? It's Mississippi, actually. I think Mississippi is the one right now that may have some serious problems with the Department of Justice because of a decision by a locality that did in fact require photo IDs that were issued by the Department of Motor Vehicles, but then shut down supposedly as a cost-saving measure, shut down Division of Motor Vehicle locations in predominantly black districts. So people could not go and get those voter registrations, and then they shut down several of the polling places, consolidating polling places. And so that's something that's in the news right now that's being challenged. And a number of states have also argued, and I think reasonably successfully, that, okay, we had these things placed on us in 1964. Our areas, our states, our locations have come a long way with these. We don't feel that these rules and restrictions should apply to us anymore. We've figured it out. We want to be released from those. And there's been an uneven acceptance of what direction to go with that. And it won't end by 2016, I can assure you. It may actually come to a real head by 2016, forcing Congress to start making some additional decisions about how they're going to legislate around these issues. So 13th, 14th, and 15th Amendments, they are at the core of general identity, I think. Of course, we have all of the others. We have subsequent legislation amendments that tell us that now, anyone over the age of 18 can vote. We had, obviously, because of tragedy, we had to set up new succession rules for the President of the United States should he become disabled or incapacitated in some way. That is a change. The two-term limit is a change to the Constitution. All of these are amendments that come post the 15th Amendments. But again, these three really do bring us back to the idea of land of the free, home of the brave, right? Everybody's free. Everybody that's born here is a citizen, and they have the right of citizenship to vote. And at the core of that, at least for me, that brings us back to the preamble, the mission of what the Constitution was all about in its first set of words. So, with that, I did 35 minutes. That's pretty good.